Hi, guys. First of all, thank you very much for staying. I know it's a difficult hour. I appreciate it. It's also a subject which many of you probably think, well, this has nothing to do with me. I'm a commercial attorney, arbitrator. Well, it has to do with each and everyone in this room, and I will prove it to you. This is not a lecture about IP. I'm not here to teach you IP. I know most of you don't deal with IP. That's fine. What I am here is to explain why you need to know the basics of IP dealing in commercial law, because in this field, as opposed to other fields, the clients don't always recognize their assets and legal rights. You see, if a client comes to you and says, I have an apartment, I have a business, you know how to deal with that. But when a client comes and says, I have a picture, I have a video, I have a business plan, I have a secret, he won't come and say, I have copyright protected work. He won't come and say, I have a trade secret. Okay, he won't recognize that asset. But you, as an attorney, must recognize it. Because how can you be an attorney and give legal advice to people if you don't know what their assets are? Okay, so the first slide is, why do we need to know it? We have to know it. Anybody dealing with commercial law must know the basics because our clients don't always recognize what kind of assets they have. So the purpose of this short lecture is basically to help you recognize the IP assets of your clients, not to teach you IP. However, I do have to say a few words about every IP right because I assume most of you do not deal with patents every day or trademarks or so on. But this lecture would be very, very practical, okay? So just to make sense of everything, I will speak about the 5 most common IP rights. Intellectual property are rights that are not physical. That's why the clients fail to recognize them so much. And I divided it to 2 types of rights. One type is the one that you must register in order to obtain the right, like patents, trademarks, design, which means that if you didn't register it, you don't have it, okay? Unlike human right or any other assets. Non-registerable right, free rights, all you have to do is recognize them as copyrights and trade secrets. And the thing to remember about these type of rights are, first of all, they're territorial rights. Okay, if you have an apartment, you have an address, you have a country. Same for technology. If you have a patent, you have monopoly only in the country where it's registered. So in other countries, people can use your product, your technology freely, and it's totally legal. So if I had a nickel every time a client comes to me and says, somebody stole my ideas, idea is not an asset. It's not a legal asset. So nobody can steal it. Okay? I can't help a client saying, somebody stole my ideas. Ideas are not assets. Technology can be an asset. Okay? So we as lawyers need to know the difference. So territorial rights, that's very important. There's no such thing as an international patent or trademark, just like there's no such thing as an international apartment. An asset is always per territory, and that's important to keep in mind. Another thing I won't be speaking about, but you need to keep in mind, is agreements, contracts, dealing with IP, like NDAs, non-disclosure agreements, or license agreement, non-compete agreements, and so on. These are contractual rights dealing with IP. I will not speak about them today. But as you lawyers know, the difference between contractual right and property right is that property right is to everybody, to the public. If I have an apartment registered in my name, I don't need to inform anybody. Nobody can come in. Same with technology. If I have a registered patent in the US, nobody can use that technology. I don't need to notify anybody. I don't need to warn anybody. There's a public registry, and people need to check before they use their technology to make sure they're not infringing my rights. So it's exactly the same. While contractual rights are only between the people who are party to the contract. So property right is always stronger. A few words about each one of them, just briefly, shortly. Patents, they protect technology, okay? Devices and methods in the field of technology. It could be any scientific field like chemistry, software, physics, mechanics, and so on. And trademarks, they protect our trademark, which means our brand, our logo, anything that connects in the consumer's mind between the goods or the services and the source of it. Designs protect the way industrial product looked from the outside, and today it's also digital designs. We'll give a few examples. Copyrights protect copyright works like a poem, a statement of claim, a story, a video, etc. And trade secrets are basically any competitive information that your client has over his competitors, which is a secret. Now, I'm going to give you two examples just to make sure that you all understand how important it is and how you all have IP around here. Let's take this table. It has a lot of IP in it, a lot. You want to try and guess? What could be a patent in this table? The way it's manufactured, the machine that manufactures it, okay? Maybe if it has a certain balance in it that somebody invented, that could be a patent. Let's go on. Design, the way it's designed, that could be protected. Nobody can sell a table looking like this because it's mine. I registered the design. Trademarks, that would be the brand or the logo or the name of the table. Copyrights, every picture you take of this table is protected by copyright. All of the commercial advertisement from the company, that's protected by copyright. If you have a guide, written guide how to make this table, how to sell, that's copyright protected. Trade secrets. Maybe the way you build it is a trade secret. Maybe it has special material inside which nobody knows about. The list of customers, the costs, business plans, all of these things are trade secrets from the manufacturer. So this table has a lot of IP in it. Simple table. Now, since you're all telling yourself, well, I don't have clients with a table. I have clients with a little more than just a small table. Let's take a law firm. A law firm has a lot of IP in it. Let's begin. What could be a patent in a law firm? What if I invented a software which takes all of my files and catalyzes it, or makes them in a certain order? Or what if I take a file which can write a statement of claim automatically after I just tell the story? Okay, that could be a patent. That's a technical device, technical method. What else? What could be a design for a law firm? A logo is a trademark, right? Trademark, what could be a trademark? The name, the logo, right? What could be a design? Yeah, furniture is, assuming you're right, they're new and nice. Also digital designs, icons. If you have an app, then the icon of the app, that's a design. User interface of your website, of your app, that's a design. Copyrights, what kind of copyrights does the law firm have? The text that they write. What else? Videos, wonderful. Almost any commercial, marketing, advertising material that you have is copyright protected. What about the terms of use on their website? That's copyright protected, right? So you have a lot of copyrights, copyright works. What about trade secrets? A law firm has a lot of trade secrets, going through their clients, their fees, their associates maybe the employment agreements with their workers. So you have everything in a law firm. And we're not that sophisticated. So imagine how much IP have our clients when they come to us, but they don't recognize it. So it's our job to recognize it. Okay, trade secrets. Now, moving on, now that you know the IP rights, I'm gonna be very practical and tell you tips for litigation and protection strategies of IP rights. So trade secrets. Basically, the best thing about a trade secret is that it's free. It doesn't cost you any money. You don't have to do anything. Just recognize it, okay, and protect it. What do I mean by protect it? Well, in each country it's a little bit different, but in Israel, for example, it says 3 conditions for a trade secret. 1, it's not in the public domain. Obviously, otherwise it won't be a secret, right? Second thing, I protect it by reasonable means. You love these as lawyers, right? Reasonable means. Go figure what that means. A judge would have a definition for that, right? And the third thing is that it gives me competitive advantage on my competitors, obviously. So where's the pitfall? Reasonable means. We need to tell our clients, these are your trade secrets, these are reasonable means. So if you have like a shop, like a supermarket, maybe reasonable means is just to lock it at the end of the day. But if you're a software company, reasonable means is backup, okay, maybe encrypting the files, and so on. So as a law firm, what is reasonable means? An alarm, getting backup for your files, okay? So we need to identify them and tell our clients what it means and what do they need to do to protect it. Copyright. Like we said, no protection for ideas, right? So copyright can be any type of these examples. Copyright is also free. So all you have to do is recognize that you have a legal asset, which you can trade, you can sell, you can license, you can do whatever you want with it. It has values. So it's 70 years from the death of the creator. Does anybody know why 70? I'll help you out. It started as 25 years, then they changed it to 50, and then to 70.
Possible that our children's children are still interested in copying like Queen's work or stealing his stuff because his legacy might no longer be present. So that was one example, and I don't know if that's correct.
Well,
or not,
the answer is much more colorful and nice. It's called Mickey Mouse.
Okay.
Yeah, really. The inventor of Mickey Mouse, the one who invented that little mouse, Walt Disney, every time he reached the end of the term, they changed the law. So after he died, right, his successors inherited the rights, made a lot of money, and 25 years passed, we're gonna lose, we changed the law. So they changed it to 50. Then 50 years passed, then they changed it to 70. And let me tell you that they'll probably change it again in 2 years because they wanna still make money out of this little mouse. They do not want it to be public domain. And since after the US, most of the countries changed the law accordingly, it might be even longer. But the thing is to remember about copyrights is that even though the creator has died, his successors still have the rights. So if it's of any interest to you, every 31st of December in Wikipedia, they have a list of things going public domain, and last year was Pooh the Bear. So if anybody wants to do a child series or write a children book with Pooh the Bear, now it's public domain, everybody can use that little nice bear. In any case, it's an automatic right. You don't need to register it. You get it automatically. In some countries, like in the US, if you want to get statutory damages, you need to deposit the creation. It's very easy. You don't even need to be a lawyer. You just fill out a form, pay $55, get a very nice certificate in your mail, and there you have it. Tell your clients to always label their copyrights their works. All rights reserved. That is super important because in some countries, the law says that if somebody that copied you didn't know he was copying, didn't know he was infringing, he may get out of it. It doesn't cost any money. Just do it. You have a nice presentation, right? You see my presentation? What does it say? All rights reserved, para-law office. It's free. Do it. Label everything. Even if you have doubt if it's copyrighted work, label it. Doesn't cost you any money. Might just save you one day.
Is the additional language obligated in some countries? Like no part of the book may be these texts that goes below the copyright statement?
It doesn't matter. Well, see, if you're in the US and you write it in some country nobody knows how to speak, it's maybe a problem, but usually English is pretty much worldwide. So, okay, so let's go. So that was free, easy rights. Let's go to the ones that actually cost us a little bit of money, and they need to be registered. All right, so we have patents, designs, and trademarks. Patents. I'm sure most of you say, oh, well, if my client has a patent, he'll go to a patent attorney. Maybe, probably. But what if he comes to you? At least know to refer him. At least know to tell him the basics. Like if you have a nice idea, that's not enough. You need to have something more substantial. And it has to be new. So if someone comes to me, and I get that a lot in Israel, there's a lot of startup companies in Israel, right? They come and say, we have a great product. We've showed it to the world. Now we have an investor. Can we patent it? No, you can't patent it. And actually, I can't help you. So bye-bye. I'm not going to make any money out of this client. He was stupid enough to show it to the whole world when the first basic rule of patents is novelty. You can only patent something that's new, that you never disclosed and nobody else disclosed in the world. So that's the basic. The other thing is inventive step, which means that it's non-obvious. This is like the basic strategies for most startup companies and entrepreneurs, which involves international treaties. Okay, I told you that the first rule was novelty. So if I didn't have all of these treaties, I would have to tell my client to register his patent in all of the countries on the same day. That doesn't make any sense. So we have these treaties giving us timetables. Okay, like file in one country, you have 1 year to file it in additional countries, and you can buy more time, 1.5 years for money. After 2.5 years, in most countries, time is up. You can't register your patent in any other country. Okay, so this is like the basic strategy. Moving on, because I have time limit. So basically, when you file a patent application in a certain country, you have 2 timetables, okay? And they don't affect each other. One is in the same country where you filed your application. The other one is the international route. You have 1 year to file in different countries. You can buy another 1.5 years. One of the strategies we do is accelerated examination. Now, I'm not going to teach you about registering patents. That's not the deal. But registering a patent in many countries can take a few years. In a lot of countries, you can get it within months. Okay? So if a client needs a patent really fast, you can refer him to someone. That's a possibility that he needs to know about. You can have a green patent, and if you have an infringement, and so on. In the US, see, if you're over the age of 65, you can get accelerated examination, and so on. You have many options for getting a patent fast. Also, this is the global PPH, so everybody now search for their country here. Most of the countries are here. This is a global PPH. What does that mean? It means that if you have a patent in one country allowed, the other countries will examine your application immediately. You will not be in line with everybody else. And that's great. So we have a lot of international strategies to get a patent fast. When to file? That's an important question because clients always ask it. First of all, they need to get their legal advice as soon as possible. They can't wait. Why? Because the novelty rule says they can't disclose it. So if a client comes and says, I have an idea, don't tell them, you know what? Go search for an investor and consult with an IP attorney later. No, he needs to consult with an IP attorney immediately because once he discloses it, he can damage himself. He may lose the right to get a patent, and he's going to blame you for not telling him to go see a patent attorney immediately. No prototype required. He doesn't need to have an actual product. He just needs to write it down on a piece of paper. That's it. Just has to make sense, right, with the law of physics and everything, but he doesn't need a product. Where to file? Where do you want to get monopoly for your product? Maybe where your competitors are? You don't actually have to use it. You don't actually have to sell it. You don't actually have to manufacture it. I have clients thinking, what would be Samsung's next step? What would they invent? Maybe a phone that can fly? I'm not sure. So they start thinking about it and thinking how they're going to manufacture it and how it's going to work. And they file a patent. They get a patent. They don't need to have the actual product. Okay, so the next thing, they can sell it to the big companies. So it's very important where I'm going to get my monopoly. Last tips. Prior publication can make registered trademark voids. What does that mean? If I want to cancel a registered patent, the easiest way to go is to show a prior application, a prior publication of the product. When I litigate an IP case and I want to cancel a patent, I tell my client, go get a private investigator, go get a search company, find me that product before the filing date of your patent, of that patent application. If he finds it, litigation is really, really easy, really quick. But if he finds something similar, that could be a little tricky. Mandatory disclosure of prior art. In many countries, the applicant of the patent application needs to inform the patent office of any publications he knows about. If he doesn't do it, the patent is void. Another great litigation tip, I use it a lot, got some patents void that way. Publications which are hard to find. I had a client publishing his product in a magazine in Japan, I believe, in Japanese, using words that were not so common. I told him, why are you doing this? And he says, I don't want anybody to find it because I know Gillette is going out with this product next year. So after they made a lot of money, he just showed us that, oh, I have a prior publication here, you know, let's talk, all right? Hurry up in times of global crisis. If there's anything we learned from COVID and the war, don't wait. I have a client who needed to file a patent in Russia. Tough luck, you know? No way. It's not possible, and there are deadlines. He's losing a huge market. That's, you know, no sympathy there or anything, not going into politics. But if you know that you're in time of crisis, don't wait. File it in all the territories that you need. Also, heads up for countries that are not in these international applications, like Argentina, Taiwan, for political reasons, and you need to file there fast. Trademarks. So, trademarks. You can't register any type of trademark you want, okay? If I want to register a trademark saying law office, well, nobody's going to give me monopoly about these words, right? What about if someone wants to get an app for, introducing business people and calls it business app. Nobody's going to give a monopoly over that, right? Because generic and descriptive trademarks cannot be registered unless specific circumstances, which we're not going to get into. But if you have arbitrary trademarks, when there's no connection between the meaning of the word and the goods and services, then you can register it. This is a trademark lighthouse. I registered a few months ago for my client the word lighthouse in Israel for trainers. My client is a personal trainer. What if I also classified it in e-discovery softwares? He could not be working anymore. I would come and tell him, oh, that's very nice. No, lose the trademark or I'm suing you. That could be a problem. So your clients need to protect their trademarks and they need to register it. And if you're a law office thinking, oh, nobody's gonna copy my name because it's not that special, let me tell you a little story about this logo. Can you see it, you guys? It's a little bit small, purple. You also have it in the presentation. One day I get an email from one of my colleagues. We won't say his name because we're not bad-mouthing our colleagues, but it starts with a B. This is a P. His starts with a B. He added a little circle to make it a B, and his name was different, but the fonts were the same. So if you look at my logo and his logo, it looks very, very much the same, and he does IP. So I wrote him an email saying, hey, that's pretty similar. And he says, well, great minds think alike. So at that point, I filed an immediate application for a registration of my trademark, right? Now I can put this R with the circle around it, right? And now I'm not gonna sue him, and he changed it. So, but I have my options. Knowing the law and knowing and having your options, your legal options, is really important, even if you're not gonna use them. So now I have monopoly about this logo in many countries, by the way, so don't think about it. This is my logo. No law office can use it. So that's important. Here are a few examples of descriptive and marks and so on. Tips for trademarks. Expedited examinations. It usually takes about 6 to 8 months to get a trademark registered. In Israel, you can get it within the first day, 1 day. I filed a trademark at 7 in the morning, and at 7 in the evening, I got an allowance. That's amazing. So you have expedited examination in many countries. So if a client needs a trademark really, really fast, it's possible. Using domestic registrations to avoid user requirements in the US. I don't know if you know, but in the US, if you want to register a trademark, you have to show that you're using it. However, if you're basing it on a foreign registration, you have 6 years. You don't have to show anything. So that's a great strategy for people. No time to waste, first to file. Avin filed a trademark application for Lighthouse. I filed a month later. Who's gonna get it? She, first to file. First to file, so hurry up and file your applications, no time to waste. Prior use matters in the US. US has to be different in most things of IP. What can you do? One of the things is, they say, well, if I've used the trademark before, then I can cancel yours. So don't wait and hurry up and register everything. EU, we have a problem with the EU. Why? Because you have these national trademarks and you have the EU trademark. Now, I'm filing for my clients a trademark in the EU, right? And then somebody from France or Germany gets out their trademark saying, oh, I have a prior registration, I'm gonna cancel yours. That's a problem. In most cases, what we do, we negotiate a compromise, saying, okay, you use that logo, I'll use a different logo, I'll change the list of goods, we compromise. But that costs money, so do very good searches. Know the difference between a word mark and a logo. A word mark gives you monopoly on the word and all designs. So when I registered Lighthouse, I registered the word. So I don't care what kind of logo they have. They can't use the word. That's it. So if you can, register a word mark. That would give you monopoly on all designs. Avoid formality refusals. Get the work done with an expert. You don't want to get, when your client gets a refusal saying, oh, the term is not drafted according to the regulations, that makes you look bad in front of the client. It makes you look like it's the first time you've ever done this. So get some help, do it right. 3D trademarks. 3D trademarks is a way to override designs. The bottle of Coca-Cola, right? It's a design because it's an industrial product. But they didn't want to have only 15 years of monopoly. That was really short time. They wanted monopoly forever. So what they did is file a trademark, because a trademark is forever. You renew it every decade, but it's forever as long as you're using it. So they got a 3D trademark. This is a very good way to overcome designs. Almost over, almost, I promise. Designs, digital designs. Many of you may recognize this Apple-Samsung issue. They were battling in the court, the US, saying, is this an infringement of a design or not? And the court says, it's not an infringement because all of you people here can look and tell me which is Samsung and which is Apple. So it's not an infringement because the customer can tell the difference. Also, in Europe and in Israel, there's an unregistered design. In certain cases, you can have 3 years of monopoly without registration. If you do register, it's 25 years, but if you don't, it could be 3 years without any registrations. So that's also something to know. There are also some grace periods, like if I published my design, I can still register it within 1 year. So in designs, sometimes in patents, also in the US, even if the client published his product, better get legal advice. In some cases, he can still register it. Software can be protected by all of them, okay? All of them. If anybody wants the presentation afterwards, I'll send it to you. Software could have design, trademark, patent, copyright, everything in it. Each part of the software is protected by different IP right. This is a summary of the IP rights with the pros and cons. Some of them are more expensive, some are less. If you want, I'll send it to you. Easy. Computer law. Stay out of it if you don't understand it. And if you are in it, understand it. Because there's a lot. We talked before about terms of use, right? So I read a study that there was an experiment. People were told to accept terms of use. Now, the terms of use said that you're selling your children to be slaves. 96% of the people accepted. That tells you almost everything you need to know about terms of use. Privacy, same thing. Privacy, data protection, it's an evolving thing. If you're not there, either learn it or get an expert. But don't make it look in front of the clients like you're not professional. That's the most important, because knowing what you don't know is just as important. And knowing when to get the expert to help you out is just as important. So thank you for bearing with me. I know I spoke really fast. Thank you. Do you have any questions?
Where is Bnei Brak?
Bnei Brak is near Tel Aviv in Israel. A very important question.
Any more?
I talk so fast, there's still...
No, actually.
Thanks.
The choice not to patent it because it's too expensive to do it, and let it go and keep ahead of the patent.
I want to tell you something about a patent. A patent is not the goal. Nobody registered the patent to get a certificate on the wall. Patent is a mean. It's a business mean to getting something you want. So if it has no value for you, it's a waste of money. If it does have value, it's worth every penny you're going to put into it. Yeah, thank you. Yeah.
Joseph has a question. Maybe the last. Because, I mean, the topic is, I mean, you can ask questions until tomorrow, but.
It's an amazing topic, IP rights, Kenyan Rouhani. Sorry. How many classes are there in a trademark, and is it possible to register both logo and word mark together? And can you sell that logo and trademark, whether it's 3D, 2D, 1D,
Yeah.
etc.?
So as lawyers, we always think how to do money out of it. Yes, of course. So there are 45 classes.
45.
Yeah, 30 until 34 it's goods, and then from 35 onwards it's services. If you're a law firm, you'll probably take one of the service classes as a law firm. You can register a logo, a word mark, a 3D mark, whatever you want. Nokia registered a sound. Like, remember when you opened the Nokia, I'm not really good at it, but when you opened their phones, it had a specific sound to it.
It was the
They
last
registered
generation.
that as a trademark. And Milka registered purple chocolate, so you can't sell a chocolate with that purple, Ferrari for the red car, and so on. So you can register almost anything as long as it actually provides a connection between you as the source of the goods or the services and the consumers. And it can be worth a lot of money.
Well, thank you so much.
Sure.
Amazing.
Maybe another big round of applause for this awesome, useful, and practical session. Thank you so much.